Welcome, everyone, to another episode of the SERMAPod. This is the podcast for the Sports and Entertainment Risk Management Alliance. I am the founder and CEO, Rich Lenkov, and joining us today is Pete Salsich III, a partner at Cape Sokol in St. Louis. Pete focuses his practice on intellectual property, media, and technology law, advising companies, producers, and creators on copyright, trademark, and licensing issues in film, television, and digital media. His work often involves entertainment errors and omissions insurance, which is what we're going to discuss today, including claims involving defamation, privacy rights, and intellectual property disputes tied to media productions. Very timely and interesting discussion.
Yeah.
Pete, welcome to the SERMAPod.
Thanks, Rich. Happy to be here.
Yeah, really interested in digging into this topic, something that increasingly is an issue for all of us in this space. We talked a little bit about this at our panel at the film festival in Utah a couple of months ago. Really great discussion. So we want to have you back to dive in a little deeper.
Yeah.
So for people who are maybe outside the entertainment industry, what exactly is entertainment errors and omissions insurance? And why do studios, producers, distributors require it before a project can be released?
Well, great question. And it's a question I often get from especially filmmakers that are sort of new in the producing side. Maybe they've worked on films and this is their first one putting together and they're sort of assembling everything. And they think about insurance for basic, general liability. A light standard falls on somebody on set or somebody's injured, workers' comp. All of those things sort of like, yeah, you got that. But the E&O insurance can sometimes be forgotten. And it's very, very important because as you know, and your listeners probably know, uh, commercial general liability policies of almost every type typically exclude under the advertising injury umbrella claims for copyright infringement, defamation, trademark infringement. Essentially any of those types of claims are excluded. So you've got to get a separate policy to cover those. And while yes, of course, you need to protect against an injury on set or workers' comp, things like that, the biggest risk any film project or television project has is likely from intellectual property claims. Somebody, you don't license the music correctly, or you decide that you aren't going to license somebody's music. You're going to have somebody compose because you think, well, that'll be better. But what they compose ends up being pretty close to some original because the script called for that. And now you get an infringement claim. And maybe it's a claim you can easily win on the merits, but the legal fees will dwarf often the budget even for the film sometimes. So
yeah, you and I were talking offline about an experience I had in my role as a producer where a film that we distributed was sued exactly under the circumstances you're describing for copyright infringement. And we ended up winning after a year with a successful motion to dismiss because we asserted fair use, which we'll get into. But to your point, we expended a ton of, thankfully not but our insurance company's legal fees. And it also took, a year out of the life of the film when you're trying to gain momentum. You only have a short window for these films as an independent producer to gain momentum. And if you're shelved basically for a year, it's really tough.
Yeah. And as the producer, once you go out into distribution, first of all, you first have the job of ensuring that you've gathered all the rights necessary to make whatever your film or television project is. So clearly, obviously that's your crew agreements, your talent agreements, those things. But particularly in the documentary world, if you're often building something based on other things that already exist. And so you're assembling and you're going to get releases here and permissions there. But sometimes you can't gather everything. But in that process, you have to gather all those rights. But then when you go to distribute, the streaming platform, studios, whoever is distributing it, you're going to be signing an agreement with them. And you're going to represent and warrant to the distributor that you have all the rights necessary. And you're going to indemnify them. So if the studio or the platform gets sued, which they will, then they're going to turn around and say, hey, here's our case. You step in under the indemnification clause, and now you're responsible for their defense, your defense, everybody else. And if you don't have insurance for that, you're done. And the other thing about it is, well, yes, that studio will hand you the case and under the indemnification clause, they'll also pull the project and say, once you get this sorted,
100%.
we'll come back and talk to you. And maybe to your point, Rich, that window, this thing has an audience right now, but who knows what's going to happen in the world a year from now? And maybe that audience just has moved on. And so it's really, really important to make sure you've got this in place.
And by the way, Pete, as you know, not only will they pull the project, but they will not want to work with you ever again, right? I mean,
Yeah,
companies
right,
don't want to be involved in litigation. As expensive it is for the producer, the studio, the streamer doesn't want to involve, they don't want to
no,
incur those kind of legal fees. So, as most of our listeners who are, and most of our, folks at our event in Utah, these are independent filmmakers, many for the first
right.
time. You don't have the track record or credibility upon
Right.
which to build a future relationship. This is your shot. And if you're involved in litigation, no one's going to, I don't want to say no one, but it's going to be very difficult to get someone to, work with you in the future if you involve them in litigation from the start.
That's absolutely right. I mean, everything in this business is, you hear the word precedent, and it's precedent and reputation. So what had you done before? Can you step up a little bit? You don't ever want to go back and whether it's a credit or something like that. But it's also you're building, what have you done for me lately? What's the last thing we experienced with you? Always leads into the next thing. And maybe this one studio, you think, yeah, but there's others. The other reality is the human beings who are making these decisions, they move around studios, the distribution platforms, they merge. All of a sudden, somebody that you haven't seen 3 projects ago is now in charge of, buying projects for this whole new platform that you want to be on. So your reputation does extend out. The word gets out. It becomes, if it's a big deal, like I'm sure yours was, it's also in the press, right? People know about it. And reporters, even good ones, have deadlines. They have only so much space. They got to get something out. They may not get the story right. And the headline writer isn't even the guy that wrote the story. And that person says, production company fails, production company infringes, alleged later. Nobody reads the alleged later. They just read
Right.
the headline. So, yeah, lots of reasons to try to, and yes, we're going to talk about the importance of the insurance policy in case that happens. But good practices are to do everything in your power to avoid having to have that situation. But sometimes when you're absolutely in the right, like you guys were, you're still going to get sued, and that's where the insurance is absolutely necessary.
I want to get into the insurance policy and maybe some exclusions because, again, reality check, even when you have a policy, like I love insurance companies, I represent them as my career, but they are going to look for a way to
Sure,
deny that claim. Just like
sure,
when you get into a car accident, you've got to fight your insurance company. No offense, but they are going to look for a way to deny coverage. We'll get to that in a
of
moment. I want to get
course,
your thoughts on that, but let's
sure.
just walk through kind of the process. So if I'm a filmmaker making my first film, making a documentary, as your example, I want to use a piece of, a photo. I want to use some video. I want to use a piece of music. What's the process to get the okay to do that? Just kind of walk us through the steps. And also where you
Well,
get involved, how you get involved.
sure. And I often will get involved. I have certainly been brought in when everything's done and, hey, can you give a fair use opinion? And then you're looking at a substantially locked cut because time codes matter. So but what from this second to that second, here's a clip. We don't have the rights. And then we're asked to give an opinion. Does this qualify under fair use? And that's a whole process. But if I'm able to get involved earlier, I often will say, well, let's look at what categories of things do you want to use? Do you know who the source is? Can you find out who the copyright owner is? Is it possible to get a license? And often we'll talk early on and say, well, yes, under this set of circumstances, my opinion, I haven't written my formal opinion letter yet, but my opinion is that if you use this clip in this way, it would qualify as fair use under the factors in the case. So perhaps outreach to the licensor, the owner, is to say something that says, we're making this film. We would like to use this clip. We have checked with our attorney and we have been assured and instructed. So we will make sure we only use it in a way that qualifies as fair use. But we would really like your permission. We'd like to have you on board. We'd like to give credit. Maybe you have better footage that you'd share with us. And because I always encourage people, yeah, fair use is available. It is very much a part of the law, but it is often, I have a law professor, a friend at St. Louis University, and she refers to fair use as expensive forgiveness. And because you don't really know if it's going to work until you've gotten sued. So I try to work with filmmakers, and let's try to get, if you can get everything clear, then we don't have to worry about fair use. But working through in categories to try to get as much cleared as possible. So you have to find out, where did I get this? Did I just pull it from YouTube? Can I scroll and learn a little bit more by reading the liner notes or the show notes or the any other details about who might be the copyright owner of this thing I want to use? Where did that come from? Can I contact them? Do they have a link if I can search for it and find it that tells me how to get permissions? Often there is a way to find that out. Now, somebody might ignore you. They may not answer the email. I mean, there's challenges, but I always start with, let's try to get permissions, because as we talked about the insurance policy, when you go through the application process on this E&O, there's a whole series of questions, right? One of them is, or a series of them, basically you're saying truthfully, you will get clearance for everything you use. And then there's a big question, if you are going to rely on fair use, then you need a clip log and opinion, things like that. But you are, to your point, Rich, you want to make sure, and I tell this people all the time, you do not want your insurance coverage denied because of something you said incorrectly on the
Right.
application. That can be
Right.
the easiest way to have your coverage denied. Application wasn't true. And it may have been a mistake. It may have been, well, I meant, doesn't matter. You do not want to have that fight also. That's a whole nother category of litigation that you don't have insurance for, right? And so it's a very important to understand at the outset that you do need to acquire rights to use other people's works. And only if you are unable to, do you then look at fair use. But be very careful in filling out your insurance application so that you're not going to find out later that you don't have coverage.
I want to ask you a couple follow-ups because those are really good points. But I'm also curious personally, sort of your role as an attorney, but also a supporter of your clients and a creative person yourself. It's got to be hard to walk the line between providing sound legal advice and, also sort of interfering with the artistic process that your clients are engaged in, right? After all, this is their vision. You don't want to
Right,
step on their vision, but you also got to explain the reality is that if you want to pursue this without a license, then there are risks associated with it. But that's
right.
got to be tough for you as well, right?
It is. It's interesting. One of the very first times I really found myself in that situation, about, I don't know, 12, 13 years ago, I was working closely with a production company, and I had been their outside counsel. And then I spent a couple years as an inside counsel, where I was much more involved in from the ground up on these projects. And I remember, sitting, looking in the editing suite, looking over the shoulder of the filmmakers, and they're showing me these clips and asking my opinion, and I'm seeing something that's problematic. And it could have been, logos in a trademark situation that don't easily fit, or, anything in particular, or maybe dialogue with somebody that then went away and you never got an appearance release, whatever the different things might be that we consider as important things to clear before submitting the film. And just having to say, that's going to be a problem. That's going to be a problem. But I also knew, if I just keep saying no, they're going to fire me and hire somebody else. So, and you're right. I want to be I'm very much, I love being part of the creative team. I'm not writing the screenplay. I'm not holding the camera. I'm not editing. But from a legal perspective, I do feel that's part of where I am. And so what I ended up talking more and more about and using this phrase is, you don't want to fall in love with footage you can't use. So talk to me way up front, before you've rolled camera, before you've got on that airplane, whatever. What's the creative look like? What's your vision? What are the types of things you might see in this show versus that show? Oh, okay. Well, that's going to raise these issues. Let's make sure that we do and you just try to give them the swim lanes, if you will, that, yeah, we may get to the point where we've got to make some tough calls on a few pieces, but you don't want to spend 2 days on set and realize later that had you just moved your camera a few feet and not had that logo in the shot the whole time, you could use everything. So a little bit of that blocking and tackling early on, um, is helpful, and that's where I try to more educate on what to avoid than to try to get in the way of the creative process. Because you're absolutely right, it's a fine line.
Yeah. No fun being Mr. No, I know. Um,
That's true.
Circling back to what you said earlier. So, what, just briefly explain kind of the process whereby you review for fair use and kind of what criteria you use in deciding whether to sign off or not on fair use.
Sure. So fair use is a it's both a well established principle under copyright law and also a crapshoot every time. There are four factors that the courts use to determine whether a piece of work is qualifies as fair use. So I'm putting together a film, and to your example, we were talking earlier, 8 seconds clip from a song or a video of something, and you don't have the rights, you don't have a license, you're not able to get that. If you use it, it's infringement. If you use someone else's work and you don't have the rights, that's copyright infringement. So fair use is a defense to what would otherwise be copyright infringement. It's not permission, it's a defense that's built based on the First Amendment. And so courts go through four factors. What is the nature of the original? If the original is a film or music or a work of literature or art or something like that, it's very creative. It's going to get a high level of protection. If it's a news story, it's going to get a much lower level of protection. It may be easier to qualify as fair use. Then what is the nature of the use that your client's doing? What is the film? What are you doing with this piece? Are you telling us, are you commenting on it? Are you telling historical retrospective and placing it at a point in time? Because the point is your use needs to be different than the intended purpose of the original. Courts will look at whether something is transformative. Have you done something different with it than the original? Um, Third factor they'll look at is, are you only using as much of the original as is necessary to make that point? So whatever point you are making, if you can make it in 4 seconds, use 4 seconds, don't use 40. And then the last question is, does your use have an impact on the financial market for the original? Are people gonna no longer buy the original because they saw your film or your clip? And so no one of those is a winner. The courts balance all of them. So as lawyers, we have to take that and go through each of these things with each film and with each clip. And so what I try to do early on is, when it's at a fairly rough cut, they by then they probably know, look, we're going to have some stuff that's music. We're going to have some stuff that's news clips or old photographs from historical society or whatever it might be. Well, then you can say, well, these categorically are more likely, if we do the analysis, to fit here. Therefore, get as many clears as you can, but this is something we probably are going to be okay on. Or we may say, those are going to be real hard. Can you do something else in the film and not use those if you don't get a permission? And we just kind of go through that process. And then at the end, when they're ready to, when they have the picture locked, I get a clip log and I get a Vimeo of it ready to go with time codes. And then I look, and they'll have a clip log of essentially the entire thing, where all the permission of all the other clips that they're doing. So not any clip that they're using from someplace else. And it'll say a time code, and then do they have the rights or not, or where did it come from? And then I have to watch it in that context. What came before, what came after, are they commenting, how does it present itself? And then I apply those four factors we just talked about and determine, yes, I believe this would qualify as fair use. Here's the basis. And we have a column, and I put notes in the clip log itself, the attorney notes, because that could end up being a piece of evidence. And then at the end of that, if they say, okay, we're good, or sometimes it's a risk tolerance thing, maybe a closer call on this or that, but the filmmaker believes in it, or the financiers believe in it, or maybe the distributor is willing to take the risk. Sometimes that happens. But whatever that is, then we end up, the final thing is when that picture's locked and those time codes are locked, is I'll issue a formal opinion letter. And it's literally you go through and you lay out the factors and, typical lawyer opinion letter. It's got a lot of qualifying things. This is not a guarantee. But in my opinion, based on this case law and this application, we believe this qualifies as fair use. And then that becomes the opinion letter that the producers can rely on later if they need to with their insurance company and perhaps with the court.
Great explanation. All right. So we're a little short on time. So I think this will unfortunately be our last question, but we'll do a follow up in the future.
I'd love to. Sure.
Yeah, this is really fascinating stuff. So despite hiring the best fair use guy in the business, Pete, you still have a claim, right? There's still a claim that's, fast forwarding to that. We talked about, exclusions. What type of exclusions might there be in an E&O policy? I know, for example, just like, a medical policy might exclude a prior health condition.
Sure.
An E&O policy might exclude your claim if you had prior knowledge of the claim. Explain that and maybe some other exclusions that insurers might use to try to deny coverage.
Well, you just hit on anything prior. I mean, it's hard to go through the long list of them, but I think it seems to me they kind of boil down to often knowledge. In other words, you go back to that application and you're going to ask a series of questions. And sometimes there's a knowledge qualifier in that question. To your knowledge, is this A or B? And you have to answer. Sometimes it's just, is this A or B? In other words, you're going to answer A or B whether you know it or not. And so, but in particularly on the knowledge questions, if you had knowledge of something and did not disclose it, and it can be categorized in a lot of different places, that's where you can get coverage. I've seen that often comes up. Sometimes it's a timing thing. It's not so much an exclusion. It's when did you learn of a possible claim? I had a situation a couple of years ago where we got word of the claim, thought it was nonsense. The client didn't notify the carrier right away. Ultimately, eventually, finally did, got coverage, but they weren't going to pay the attorney's fees that were done that were really responsible for a good result, but they were all incurred prior to giving notice to the carrier. So sometimes it's a timing thing, but often it's a knowledge thing. Be very, very careful on anything that asks, to your knowledge, is this? Because that becomes, you've got to make sure if there's something, and knowledge doesn't just mean, yes, I know it here. Knowledge means with reasonable investigation, could you have determined this? So you can't just say, no, I don't know anything. You got to say, hey, does anybody here in the company know this? Have we had anything happen before I got the job? Something like that. Knowledge is a broader category than just what you know right that minute. So maybe that seems to me the biggest catch-all.
I assume that a carrier couldn't deny the claim based on arguing, for example, the fair use opinion was invalid because they wouldn't have issued the policy in the first place if they didn't sign off on the fair use opinion. Is that right or no?
I think that's right. I mean, the way I've seen it happen is when in the application process, again, have you cleared or will you clear all people, all rights, all clips, and then do you intend to rely on fair use? Well, if there's any chance that you have made, even if at the end of the day you get it all cleared, you're going to check yes at that application stage. So you're putting them on notice. And then it typically says, if yes, please provide a clip log and opinion letter to support this. So you're going to submit that clip log and opinion letter to the insurance carrier up front before your thing goes out. And they're not going to look at it. They're not going to say, yes, we agree. But that's how you can preserve that you've taken the steps to put them on notice. And then if they issue the policy and you have done those things, then they can't say, we're denying coverage because there's a fair use claim. But if you don't click yes there, even if you later get the fair use opinion and get the clip log, you have given an opening for them. Hey, you didn't tell us. We issued this without, you'd never checked the box on fair use. So we're denying because you didn't have all the clearances. So it's very much a point. It's important during that application process to have some pretty good idea of what you're going to be doing in this thing, because you don't just get the same policy. I mean, you might end up with virtually the same policy every time, but each time is a new project. Each time you need to be careful in the application.
Great stuff. IP lawyer, guitar player. I know you're a rock and roller. You're an adjunct professor at St. Louis University Law School teaching IP. Thanks so much for coming on, Pete. And are the other Pete Salsiches, were they lawyers before you also, or you
My
the first?
my dad is is now retired, but he was a law professor, practiced for a little while, then a law professor for many years. So in fact, I didn't go to law school till I was 30 because I was putting off law school. I kept saying, I'm not going to law school. And then eventually, yeah, I went to law school. So, but yes, so I'm the second, but the first and the fourth, not lawyers, nothing to do with it. So just the two middle guys.
Awesome. The website is capessokol.com. Pete, thanks so much for joining us on the SERMAPod.
My pleasure, Rich. Great to be with you, and let's do it again.